Good afternoon, everyone. My name is Jamal Zavali, and I'm the student at the Center for Public Legal Education of Alberta, CPLEA for short. Welcome to our 1-hour webinar this afternoon called the Mastering the Home Process. I will introduce our panelists just in a few moments, but before we have some housekeeping rules, we have Jessica monitoring the chat and the presentation. She will be posting useful information as we go through this presentation today. I would like to make a land acknowledgement. The CPLEA respectfully acknowledges that we are located across Treaty 4, 5, 6, 7, 8, and 10 territories, and respects the histories, languages, and cultures of the First Nations, Métis, Inuit, and First Peoples of Canada, whose presence continues to enrich our vibrant community. So, disclaimer, this presentation contains legal information only and no legal advice. For funding, we'd like to thank our funders, the Alberta Law Foundation, the Department of Justice of Canada, and the Alberta Real Estate Foundation for making these webinar series possible. We will be recording this webinar for on-demand viewing on the CPLEA YouTube channel. Save questions to the end, please. Use the Q&A functions through Zoom. It should be at the bottom of your screen. At the end, you'll be prompted to complete a short survey when you exit the webinar. So CPLEA is a nonprofit organization serving all of Alberta. We provide legal information and education through our various booklets, tip sheets, websites, and our webinars such as like these webinars. Our goal is to make the law available for Albertans and to be able for them to use this law when they need. And this is our website. You can find us at cplea.ca. So thank you, Roshan, for joining us today. We have Roshan Kalra, partner at SPLLP. He is a team lead of the corporate group at SB. Roshan's practice primarily focuses on transactional matters related to commercial purchases and sales, real estate development, real estate secured lending, and franchise matters. I'd like to give a few moments for Roshan to further introduce himself in the webinar.
Thanks, Jamal. Happy to be here and join this seminar. So as mentioned, my name is Roshan Kalra. I'm one of the managing partners at SPLLP. We're a mid-sized law firm in the south side of Edmonton with about 20 lawyers. So I've been practicing here for about 12 years, practicing mainly in commercial residential real estate, business law, and general commercial and corporate law as well. Worked with a lot of new homeowners, business owners, and so happy to be here and provide some information and answer questions today.
Thank you very much. Yep. Sorry, here on our panelists here, we have second panelist Tuba Pastutmaz, a realtor at Homes and Gardens Real Estate Limited. Tuba with over a decade of real estate experience. She has been helping clients find their dream home since 2011, starting her career with Remax Real Estate and now proudly part of Homes and Gardens Real Estate Ltd. since 2016. I'd like to also give a few moments to Tuba to further introduce herself in the webinar.
Thank you so much, Jamal. Good afternoon, everyone. Thank you for inviting me to this webinar. And as you mentioned, my name is Tuba Pastutmaz. I've been with Homes and Gardens since 2016, but I've been a realtor since 2011. And I do specialize in residential, and sometimes I also do rural property purchases and sales, as well as I help a lot of new home buyers and investors. And this is how it goes on. Thank you for having me.
Thank you. We really, as the CPLEA team, appreciate your being here today. Same with Roshan, and your words are very valuable to us today. So our first question here, Roshan, directed at you. We have, what are the key legal documents required when selling a property in Alberta, and what should sellers be aware of in these documents?
Sure. So, I mean, the first step in the process typically would start with Tuba actually, and that's the real estate purchase contract. So that is it's the main document that effectively outlines the terms and conditions of your sale or purchase, including the sale price, possession date, deposit amounts, conditions, things like that. And so it's important as a buyer or seller to ensure that all the terms are accurate. Understand you've included any clauses related to conditions. Typically, if you're buying, you probably would want to see financing conditions if you're getting a mortgage, an inspection condition to inspect the property, and then ensure those are all put in for certain dates. You may also see in a contract provisions to deal with any repairs to the property or additional terms if there's issues found at the property, or as we'll talk about later, if there's any tenants in the property, how those need to be dealt with. As a seller in Alberta, you'll also need to provide what's called a real property report, which is basically a survey of the property, outlining the boundaries, ensuring the property, everything built on it is actually within your legal boundaries. And then that gets then certified by the city or the municipality that you're living in to confirm that it's compliant with various zoning bylaws. If you're selling condos in Alberta, you'll also need to provide estoppel certificates. Those are effectively certificates confirming that any dues payable by the property are up to date, that there's nothing owing. That's something your lawyer typically would work to provide at closing, but that's something that you should be aware of as well. Other items that you should be aware of, if you're an individual that's only one person on title, you need to be aware of in Alberta, there's something called the Dower Act, meaning if there's only one person on title, if you're married, you need to have your spouse's consent if either of you have lived on that property before. So obviously dealing with that in advance is key. We find that can oftentimes cause sometimes hiccups or delays at closing. If you're selling a property under either a power of attorney or if someone's passed away under probate, making sure you have a probate grant from the courts. That now is quite a bit quicker than it used to take about a year ago. And before that, lawyers are able to get that within 4 to 8 weeks, as opposed to 4 to 6 months, what was taken before. And a lot of times your realtor will ask to see a copy of that if you're selling a property as either an executor of a property or by a probate. Last item I think I want to mention here that documents you should be required on closing is if you're selling a property as a non-resident. This has come to the forefront quite a bit in the last 2 years. You would have heard buzzwords. Some provinces, BC notably, has taken steps. But non-resident, if you're selling a property in Canada as a non-resident of Canada, there are certain holdbacks under the Tax Act, which the lawyers will have to do at closing. And unfortunately, a lot of non-resident sellers are not aware of this. And what that requires is 25% of your gross sale proceeds effectively held back on closing until you obtained a clearance certificate from the CRA. Getting that clearance certificate can take about 6 months, we find. And so the key there is 25% of gross sale proceeds, right? So if your equity in the property is less than that amount, that often results in a seller having to come up with money at closing to even be able to complete that deal, which either they're not aware of or don't have that money. So ensuring, if you're a non-resident, having that conversation right at the onset with your realtor is critical to ensure you don't have hiccups when it comes, to time of closing. So I think that that covers the key items when selling. What documents or items you should have on hand or be aware of when starting the process.
Mm-hmm. Yeah, thank you, Roshan, for that, and a great insightful information on how what kind of legal documents we need when selling a house. So moving on to Tuba now, our question we have here for you is, how do home staging and presentation affect the selling process, and what is the most impactful ways to prepare for a home listing?
Home listing, yeah.
Yeah.
So Yeah, a well-staged home often is going to sell faster and at a higher price compared to homes that haven't been prepared for the sale. And when I say home staging, I don't necessarily mean hiring a professional staging company to make your home look like a show home. While it's recommended, most sellers don't have the budget for it. Usually we ask the sellers to declutter their homes and store anything they won't be using in the coming weeks, especially items that don't match the decor. And I know this may sound basic, but cleaning is the key. A deep clean goes a long way when listing a home for sale. I always urge my sellers to keep their home as clean as possible. Like, I understand this can be demanding, especially with kids and pets, but trust me, at the end, it pays off and it makes the home sell much faster. I also recommend depersonalizing the space by removing family photos and religious artifacts so that, when the potential buyers are walking into the home, they're able to envision themselves as they walk in. And other practical tips would be for the sellers to keep walkways and driveways shoveled in the winter and lawns trimmed in the summer, just to ensure that the property appears well maintained, and safe for the buyers to walk in. And by showcasing the property's potential, it makes it easier for the sellers to emotionally connect with the space. And we can put a sold sign much more sooner on that. And we come in after with our professional photographers, and they take really nice professional pictures, and the home is ready for sale.
Yeah, great. Thank you for that, Tuba. Just before we move on, I'd like to make a quick note. I am receiving a lot of questions from the chat, but those questions will be answered at the end. We'll have a Q&A section. After Roshan's answering of his question, we got a few questions from the Dower Act and more questions about legal documents. And if we have time at the end, we'll try to go through as many as we can. So yeah, continuing with YouTube, what factors should sellers consider when evaluating multiple offers, especially in a competitive market just like Alberta?
Yes, so we are definitely in a seller's market right now in Alberta. In competitive markets like these, multiple offer situations become common. And what happens is the seller needs to consider a variety of factors to ensure that they select the offer that meets their price point and minimizes their risks beyond just choosing for the highest bid. The factors to consider when receiving a multiple offer includes, does it meet the client's expected possession date? Are there any conditions on the offer, like Roshan mentioned previously, finance condition, inspection condition? Is there a sale of the buyer's current home condition? We are seeing many aggressive unconditional offers lately. And as the realtor representing the seller, it's essential to take time to contact the buyer's agent. We pick up the phone and we gather more information about the buyer's finance. If the buyer needs financing, the bank may or may not approve the deal after the appraisal. So especially if the offer was excessively high, this could lead to the deal falling apart. I always recommend a strong deposit to protect the seller in that case. And if anything goes wrong, especially in those situations, the deposit will protect the seller again. And this is why working with an experienced realtor is crucial. We help the sellers navigate multiple offers, and we assess the factors that might not be immediately obvious. And once the deal is firm, a good lawyer becomes essential to ensure a smooth closing process, and Roshan can tell about us about that.
Yeah, thank you for that, Tuba. And moving on with Roshan here.
Yeah.
What legal issues can arise from selling a property with tenants still living in it? Yes, you did touch upon it. You said you would talk later in the webinar, and here it comes. So,
Yes.
And how can these be handled in different situations?
So I think the biggest key here is to determine, obviously, when you're buying or selling, and have that discussion at the lot of these issues can be avoided right at the offer stage. So you need to determine, are you buying a house and accepting the tenants in there or not accepting the tenants in there, right? So let's start on the basis that you are accepting the tenants in there, right? If you're accepting the tenants in there, then obviously you need to understand that they have a right to stay in that property. You'll want to review their the existing lease that they have, right? You're now bound as a landlord after that, and subject, they have rights under the Residential Tenancies Act, the RTA. Obviously, if they stay on, you sign your lease assignments, hopefully issues won't arise at that point. Your problem is if you are not accepting the tenants here in this property, right? So at that point, obviously, again, you need to review the lease terms and determine, is this a fixed term lease or a month-to-month lease, right? The seller should understand those to understand the remaining term. Ideally, you're selling close to enough time when the lease expires. If it's a fixed term lease, a tenant is entitled to stay until the end unless there's an agreement to terminate early. For month to month, you have to give the tenant notice to vacate, but you have to comply with that proper notice period, which is 90 days for termination without cause. Obviously, there's other situations and exceptions within the RTA of how you can terminate if you're buying. Again, those are more narrow focused and narrow in scope. And we can talk, if you have questions, I'm happy to answer those separately. Otherwise, the tenant does have rights to stay in that property, right? And so the issue is the buyer may want to live in that property, but then needs to go through the process of evicting tenants, and say that has not been done at closing, right? If that has not been done at closing, and you want to evict tenants, you have to follow the process under the Residential Tenancy Act, and tenants can only be evicted for specific reasons under the RTA. Non-payment of rent and or violation of a lease agreement is the most common. And then there's special circumstances. Again, as I mentioned, if the buyer intends to move into the property or demolish and rebuild or renovate, something like that. But those are the most common issues that'll come with tenants still in the property, right? That you should be aware of.
Mm-hmm. So just a follow-up there, like let's say a more of a generic question, if the tenants don't want to move out and then the buyer wants them to move out and then they force it, what are the reparations there or any problems that might arise there?
So let's say that's on the basis that you signed a purchase contract that you're not accepting the tenants, right? That the landlord is obligated to terminate that lease prior to closing. So under a purchase contract, in that case, there's a clause in there that they have to provide what's called vacant possession, i.e. everyone needs to be out of there. And so if you're not accepting tenants, and let's assume landlord provided the proper notice period, this ideal world, as Tua will say, no contract ever is ideal situation, but let's say a contract is signed 3 months before closing, you're not accepting the tenants, the landlord provides notice 90 days before to terminate if it's a month-to-month lease. We get to the closing day and the tenant hasn't left, right? Unfortunately, even in that case, you'll have to go and follow the provisions of the Residential Tenancy Act. That may be dealing with the dispute board and getting an order for possession, dealing with bailiffs to actually have eviction effected under a legal route. It happens, it's not common, but when it does happen, you'll have to go that legal route, which can unfortunately take time and cost money. And a lot of times you'll see that'll delay or impact closing if that situation is coming up. A buyer, a tenant has not left on the closing date. Worst case scenario, they don't find this out until money's already been paid and they get keys and they see the tenant is still in there. They've lost a lot of the leverage. And so a lot of times what we'll recommend is and you'll see walkthroughs being scheduled either 24 hours prior to closing to ensure it's cleared out or something to that effect, right? So especially when there's tenants in there to help alleviate that issue.
Sounds good. Thank you very much on that insight. So continuing with you again, Roshan, what role does a lawyer play during the closing process? We did mention the closing process a few times throughout this webinar, and how can they ensure that everything is in order for a smooth transaction?
Yeah. So the lawyers, has a few key roles. The first is reviewing, preparing legal documents. So that's reviewing the title to the property, ensuring the ownership, verifying ownership of the property, ensuring there are no liens, encumbrances, or titles that could affect the sale. Lawyers also on a sale will deal with the transfer of land documents, so preparing, drafting those necessary documents to transfer ownership from a seller to a buyer. They'll also do, lawyers will do searches on the property for taxes, for example, to ensure taxes are up to date, there's nothing outstanding. On a sale, one of the lawyer's primary tasks is to ensure that the title is clear. So meaning there's no issues with property's legal ownership. That'll mean either on a sale, arranging the discharge of that mortgage from the property title. So when a lawyer receives money from a buyer's lawyer on closing, they'll pay out the debt, ensure that's settled, and then deal with getting the existing mortgage taken off from a seller for a buyer. Likewise, if you're dealing on a buy side as a lawyer, you're responsible to ensure that a mortgage, the buyer's mortgage, is received, reviewed, prepared, signed, and then subsequently registered on title. So you're also acting for the bank in that case to do that side of things, and then pay the seller on closing. So that role is more on the facilitating the closing and the financial transaction side of things, right? So a lawyer will prepare and review a closing statement, or what we call a statement of adjustments. It outlines the financial aspects of a transaction: purchase price, deposits, property tax adjustments, or other closing costs that ensure that both the buyer and seller are properly credited or debited for any prepaid or outstanding expenses. And then, as I said, funds transfer, or sometimes lawyers hold money in trust until certain conditions are met post-closing. So we're dealing with that as well. And then just the last couple of items, lawyers will deal with registration of documents, as I mentioned. So ensuring that when you're buying a house, property is registered in your name, mortgage is registered on your title. Alberta still is a bit of the dinosaur age, so everything's still done by hand for property registration. So right now, just looking before this seminar, it's taking about 6.5 weeks to register documents at land titles. Meaning, if you're closing your property on November 1st, the property is actually not going to be registered in your name till about middle of December. And so, there are certain things lawyers have to do to ensure that gap is covered, to make sure nothing happens with your property. And then, once closing day comes, money is paid, lawyers will work with your realtor to notify them so they can deal with possession and handover of keys on the closing date.
You guys are also the ones paying us, right?
That's right.
What?
Yeah. So we do. That's right. So yeah, we finalize that transaction and deal with the disbursement of funds. So that's, whether it's to your lender, whether it's to the realtor, after the deal, any money that needs to go back to the client, we deal with all that.
Yeah, thank you. And yeah, Tuba, you jumped in there. I was going to ask you, do you have a perspective as a realtor to this question, and how a smooth transaction would play?
So the lawyer plays a crucial role in closing a transaction. As I said, if as soon as they receive conveyancing, their assistants pick up the file and they start working one-on-one with the buyers or the sellers. And a good lawyer can make a huge difference, especially when the deal goes sideways. You see right now that right away the difference between different lawyers, right? And Roshan can say it's when the deal goes sideways that we need the lawyers the most. And they're very helpful at that end. When he mentioned tenants, real property reports, or we are even seeing properties with tons of garbages left at the end. And the lawyer, we just make a quick call to the lawyers, and they step in right away and they try to solve the problem.
That was good. Great. Thank you very much for that. So now we are in our Q&A phase. We have a few questions. I'd like to give a minute or two for the audience to ask more. We already have a few questions in the chat.
So I see a couple questions in there that I'm happy to step in on. Looks like there's two questions regarding, people had questions on the Dower in terms of
Exactly.
ownership, owning a condo before getting married. So the answer is yes and no. If even if you owned it before getting married, if either yourself or your spouse has lived in that property at any time since the date of your marriage, you then need the permission to sell. So, you know, if on January 1st, I own a condo by myself, if on July 1st I get married and I decide on November, and myself and my partner, or even one of us, live in that property at any time since following July 1st, we sell the property on November 1st, you'd still need the permission. That property is then considered matrimonial property under the Dower Act, and because either of you have lived there at any time since your marriage, it doesn't matter if you owned it before, you need permission to sell.
I see an anonymous attendee, and I guess that question is for me. They wrote, is there a percentage that you would discount on the sale of a condo for a condo sale if I started a renovation and it's 80% or 85% finished, but not totally done in this market, which I assume is good? Could you sell it with only a little left to be completed? Well, my question would be, why didn't you complete it 100%, right? But let's say for any reason that wasn't complete, it would be priced based on the completion, right? And it really depends, especially when they say a condo, is it an apartment condo or is it a townhome condo where the what's not completed is just the basement, which we see very often. And we would consider all the factors, and we would price it based on comparables anyways. And if that part is not completed, we would deduct it with amount base, with depending what's not completed. But we always recommend, if you started a renovation project, don't leave it half and try to complete it before listing the property. And I see, I guess there was another, one good question here, and it is, what options are there to sell a property without a real estate agent? Obviously, I don't recommend it, right? And again, people will venture themselves and trying to list their home on their own, but they're going to either end up calling a realtor to get information or a lawyer. And how we suggest, sometimes I do take over some for sale by owner because it's so overwhelming. As I said, did they price the home properly? Did they market the home properly? And when there's showings coming in, especially in this market, it can get very, very busy. And they can get very overwhelmed with that. So a good real estate agent will always help you. So my answer would be no to that question.
There's a follow-up here I see on the Dower question. So the question is, what if you both lived in a different house after marriage, and your spouse never lived in your condo? Do you still need your spouse's permission to sell? Again, it comes back, if after the date of your marriage, neither of you lived in there, then no, you don't, right? So then there's an exemption for that. But if either of you lived in that condo at any time after your marriage, you would then, that gets treated as matrimonial property. So again, let's say July 1st, you get married, and then July 1st, you moved into a different house. So neither of you lived in that condo after the date of your marriage, then no, you don't need permission to sell. And then a separate question I see here, what if there are two people who signed on the condo for buying, For instance, my wife signed for buying the condo, but my mother-in-law is on the documents for the condo. So does my mother-in-law have to give permission as well? Perhaps just clarify, but if two people are on title, then I think this is the question. Long story short, if two people are on the contract and two people are on the title to the condo, then both people would need to sign or permission or give authority to sign and sell that condo. So if person A and mother-in-law are both on the title, they both need to sign the transfer.
I see a question about poly B. And what poly B is it's a type of piping that they use in the 90s. And there was many lawsuits against those in the States mainly, right? And Irina wrote here, how to disclose that house that was built in 1996 has poly B pipes that were banned in Canada in 2006. How can I protect myself from potential future lawsuits if these pipes leaks? So poly B is not considered material latent defect right now. And we do continue to sell homes that have been built in the 90s with poly B inside. And obviously, we do recommend to have those changed because it does affect the price a little bit. It can cost up to from $10,000 to $15,000 to the new buyers when there's poly B. And the issue we have with poly B more than the leaks, like the inspector would say, it's more insurance purpose. So the new buyers are having a little bit of trouble insuring the property, but there's still some insurance companies that will insure with poly B in. So no, you don't have to disclose it, but I always like to put in the private remarks poly B so that the buyers are aware before they walk in the property.
And just to maybe add on to that, Roshan, what are the repercussions of maybe a lawsuit that does happen there? Do you know anything of that?
A lawsuit on
Poly B leaks.
I have actually never seen or been involved in one in 12 years.
Okay.
I mean, if it comes up, then yeah, I mean, you're having to respond to it, right? So
Yeah.
typically we have seen sometimes, the diligent parties will put disclosures into the purchase contract to notify everyone. But
Mhm.
I mean, if there's lawsuits in the future, you would
Yeah.
unfortunately have to deal with it, right? And so keeping in mind there's limitation periods, potentially you may deal with 2-year limitation periods, but
Mhm.
you'd have to deal with any other lawsuit, right, as it comes
Yeah, no,
up. So
exactly.
yeah.
Yeah, no, thank you. That was just because it's a really common thing that's been going around since it's been banned. So I thought maybe there are some stories you could have gave us on here at the webinar. We have some other questions here about the poly B question.
She added here that it can
Yeah.
cost more than 15,000. Yes, the part with the drywall cleaning up and fixing the pipes, she's correct on that one. I was just talking about changing the pipes itself. Depending, sometimes it's a little bit cheaper on bungalows. I had one done recently, it cost $8,500 to fix, but she's right. The drywall and also what we see is, let's say there's a tub there and there are those jacuzzi tubs and there's tiling around it. Yes, the price can go a little bit up, but I always recommend to the sellers that have poly B to even if they can't afford to have the poly B change, it's always good to have 2 quotes from contractors so that we can put on the table showing this is the price that it will cost if there is any problem. But coming back to poly B, I just think that it's people are getting scared about it lately, but I done many sales with homes in the 90s, never has it happened in Canada that I heard a poly B bursting. And it's because I heard from my inspector that in the States, because it can get extremely hot and the temperature, poly B apparently burst when it's extremely hot temperature. So I don't think it's going to happen in Canada, but let's say it does happen. And it does scare buyers away, and Irina is right. But a good inspector would never scare them and say, this is going to burst or something bad is going to happen, right? It's just, you have to either live with it or purchase it and change it if you want to have an ease of mind, right? You just have to do it.
A question here from Walter, pretty interesting. How do you know that your buyer is legit before letting just anyone into the person's property? Do you request a criminal check beforehand?
No, we do not know. We don't do a criminal check on our buyers, but I do ask to receive an ID, right? And unfortunately, it's very rare that a fraud could happen, but I don't walk in a property with a buyer that just called without giving me any information. I ask them if they're pre-approved for mortgage, who their mortgage broker is, and there's so many questions that you have to ask before just showing the property. Sometimes buyers don't want to answer those questions. And even sometimes I even ask for the buyer's brokerage agreement to be signed before I even show the property if I feel something is not right there. And usually there's not many people around, pretending to be buyers, and they are legit buyers. And when we question them, you will feel it. Have I turned buyers away from showing properties? Yes, definitely. They didn't want to share their IDs, their driver's license. And I just turned them down. It's not safe for myself and for the seller, right? Because it's it's their property.
Yeah, great. Thank you. Roshan, maybe a follow-up for you. Can you put in the contract that you can, in quotations, cancel the contract if tenants are still in there after the closing date?
You could put anything you want in the contract, right? Obviously, if it's not trying to contract out a law, but this is more a practical question. So if you're a seller trying to put that in a contract, why would a buyer ever accept that, right? Buyer's going to spend time and money inspecting the property, getting their mortgage financing, spending time packing up their own house, moving, and then all of a sudden on the closing date, if the seller has the ability to terminate the contract because the seller hasn't moved out, I don't know anybody, and I'm sure Tuba would agree, I don't think there's any buyer that would ever accept that and sign a contract of that nature, right? So that's the practical side of things. Legal side of things, sure, you can, but practically, I don't think any buyer would ever agree to a term like that.
So I see another question here. What obligation does a seller have in disclosing any property defect or a problem during the sale of the process? They have to disclose any material latent defect. Yes, problems can arise if they don't. As Roshan mentioned, even if it's further down the line and they did try to hide a material latent defect, legal actions can come after them. But we have to understand that a material latent defect is not the same as a regular defect, right? A scratch on the flooring is not something you have to disclose, or a little broken window, sometimes a handle, that's not something you have to disclose. Those will pop up at inspection anyways if you'd hire an inspector. But we're talking about crack in the foundation, or like a big problem like sewer lines not. If the seller knows about it and they didn't disclose it, and they're major expensive items to fix, yes, you can have problems in the future, even after the funds have been given out, and legal actions can follow those.
Yeah, I mean, just as a follow-up on that, I think too, what you mentioned that the threshold is material, like you said, material latent defect, right? So that the threshold of that is more than, like you said, a scratch, right? It really comes down to, would that have affected your reasonably affected a person's decision to buy, or would have reasonably affected the value of the property, right? Materially affected that value. And so if the answer to that is yes, then yes, there's an obligation of a seller to disclose, right? So for example, if you knew about a large crack in the wall of the basement that may be hidden behind a drywall, right, that an inspector may not be able to see, and you didn't disclose that, yeah, you probably have an issue as a seller. So just a separate, I see a follow-up question on the previous one about canceling the contract, and the question is, can the buyer put in there? Yes, I mean, a buyer can put in there that if the seller fails to provide vacant possession, they can terminate. It's good to have, I mean, there's already something in the contract that says a vacant possession has to be provided, right? But it's in terms of whether you can terminate and have termination rights. Typically, that's something that's litigated. So if you put a clear clause into the contract that says they have the ability to terminate if vacant possession is not provided, I think that would help for sure. So yes, the answer to that, short answer is yes, you can do that.
Tuba, just another follow-up for you with the disclosing. There's a question where it says, what are the rules of disclosing a death on property when selling? Do you have anything about that to add?
I can't see that one. Is it? Let me see. What's the question? Say that again.
It says, what are the rules of disclosing a death on the property when selling?
If the question is asked, you have to disclose there was a death in the property. And there's some cultures, they're very picky about that. And if the buyer, for example, can't, and they also have some rules saying if it's a natural death or if it's something criminal happened in the property. If the question is asked, you have to say the truth, but you don't have to necessarily write there, a person died in this property, right?
Mhm.
But it's always good to put it in. It's always good to disclose in the private remarks, because a lot of, again, cultures don't want that. But obviously, let's be honest, there's so many homes in Alberta, and if you start disclosing there has been a death in this property, if you go back, we always write, if they ask me, I say to the best of my knowledge. We ask the seller, is there did someone die in this property? Because the question was asked, and if they say no or I don't know, we just tell the buyer's agent or the buyer. We have to be honest about that. But we don't have to disclose that in the private remarks or publicly. It doesn't have to be disclosed.
And another question maybe directed at you. You talked about home staging and how it can be effective. And then there's a question in the chat asking, is having an open house as effective? And what are your thoughts on that?
Open house used to be extremely effective when everything wasn't so open on social media, and we would do the open house and people would come in. But now with social media, I find that having a 3D walkthrough and having everything online is much more favorable. Obviously, yes, we do open houses. Do I get a good turnout about those ones? Unfortunately, not. But I do pick up a couple of buyers out of those. Yes, I would recommend an open house for sure. A good open house is great for the sale. But is it as effective as being very present on social media? I would say no.
Well, yeah, we've reached our 45-minute mark with our webinar today. If you do have any further questions, please let's stay connected. Visit our website at cp.ca. If you do want more further information, like I said, visit our website. We have many informative blogs, webinar series from the past, and you can watch them and inform on yourself on there. And lastly, we'd like to thank our panelists for taking their time out of the day and come and join us with this webinar with their informative talk and letting us know with different issues with different legal matters. A great realtor perspective, a great law legal perspective, and a special thank you to our audience for coming out and tuning in through Zoom today and watching our webinar series. And thank you very much, everyone.
Thank you so much for having us.
Thank you so much. Yeah.
Thank you. Thank you.